Hello learner, you are welcome on this SWAYAM platform where we are dealing with the course Understanding Competition Law, Theory and Practice. I am your mentor and we are dealing with this course since last 13th lecture. So today we'll continue with lecture number 14, that is module 3, week 3 and lecture number 4. With today's session, we will discuss here the rules applying to the interpretation of anti-competitive agreements in India. And the objectives of today's session is to discuss the rules relating to interpretation of anti-competitive agreement and to discuss the meaning of rule of reason. So before coming to discussion about the rule of interpretation, let's have a look on the previous lecture where we have discussed the meaning of appreciable adverse impact on competition within the market in India. Actually, the important thing is what we are discussing from last 2 or 3 lecture, that there is any agreement, and if the agreement have some appreciable adverse impact in market in India, that would be void under section 3 subclause 2. For this, that means to bring the application of section 3, it is note or pertinent to note that there must be the effect of imperishability or appreciability, and there are 2 elements which are required, one the agreement and second one is appreciable. And appreciable is a term which is actually not defined in the act, but for that purpose appreciable adverse impact is necessary. You have to prove that there is appreciable adverse impact. So now the question is how one can determine or how one can reference that there is appreciable adverse effect on market, so that there are certain parameter. Actually the parameter are given under section 19 subclause 3, where CCI can rely on the parameter in section 19 subclause 3. There are 6 elements. CCI can rely even any of the parameter given in section 19 subclause 3 to testify whether it comes within the meaning of appreciable adverse impact on market in India or not. So to establish the appreciable adverse impact on competition, there are certain key elements there must be present. The appreciability. The adverse effect of competition must be significant and substantial. Minor or insignificant effect are not considered appreciable. Adversity. The effect must be adverse, meaning it may harm or negative impact, and effect of competition, which the impact of competition in a relevant market. So with this, we have discussed in last lecture the meaning of appreciable adverse effect on competition within India. Now, there are some rules or rules for interpretation. How the CCI or any commission or even sometime court will interpret the meaning of appreciability in a scenario which is exist or which are existing in the market against some arguments are relying. In India, the interpretation of anti-competitive agreement is governed by Competition Act, the rules and regulation framed thereunder. There are certain rules which applies to the interpretation of anti-competitive agreement in India, and the rules are the rule of reason. Rule of reason means the Competition Commission of India applies the rule of reason to determine whether an agreement is anti-competitive. This involves assessing whether the agreement has a significant adverse impact on competition in market, the substantial licensing or lessening of competition. The CCI assess whether the agreement substantially lessens competition in the market. If it is, this require a evaluation of degree on which the competition is reduced. And there are 2 more rules for interpretation, that is per se rule and de minimis rule. Per se rules refer that certain agreement such as cartel or bid rigging are considered per se void. That means there is no requirement, no further requirement of any inquiry, because they are absolutely anti-competitive and prohibited under the Competition Act. And on the other hand, de minimis rule is a rule which may apply by the CCI sometimes, which actually provides the agreement with a negligible impact. Yani, negligible impact on competition may be exempt from the prohibition or anti-competitive practices. So with this, there are certainly two rules which is important for the purpose of interpretation, that is rule of reason and rule per se. Appreciable adverse impact on competition. While defining or determining, CCI checks whether the agreement has an appreciable adverse effect on competition in market. This involves assessing whether the agreement has an appreciable in market. It involves which leads to foreclosure of competition, creates barrier to entry, or reduces consumer choice. So for this, that means CCI, what CCI checks? CCI only check whether there is a appreciable adverse impact or not. And to find out whether there is appreciable adverse impact or not, CCI actually looks on the probability or the possibility of the act or conduct or practice for which is a least practice. And CCI found, or CCI believe that by assessing on certain factor, that it will lead to the foreclosure of competition, reducement of competition, or it will create some barrier to entry or reduce consumer choice. On such case, it may be regarded as appreciable adverse impact on competition. Certainly, there are two rules of application where CCI relies, that is rule of reason and rule per se. So let's start with this rule of reason. What is rule of reason actually? Under the rule of reason, court examines whether both positive and negative effect of an agreement before determining whether it violates antitrust laws. And court consider several factors in making their determination, such as the business purpose of the agreement, market power of the parties involved, competition within the relevant market, and other market circumstances. On the other hand, the per se rule is legal doctrine that assumes certain business practice are illegal without needing to examine their effect on competition, and it's used to determine the legality of agreement between the companies. So certainly there are two rules on which the whole Competition Act is involved. That means actually earlier there are only two rules, but under discourse you will find that these two rules are not only the rules. There are so many interpretation rules on the basis of court may examine or CCI may examine, but certainly in antitrust law these two popular rules are there and which may applicable to find out or determine the impact of the agreement or conduct, whether it is appreciably or substantially adverse impact on market is or not. So have a start with the rule of reason in detail. In case of rule of reason, the pro-competitive effect are balanced with anti-competitive effect. Certainly this rule is not actually rule where you have to find out the only impact which is in negative or any impact which is positive or not. But you have to balance, you have to take out the balance if there are some argument in favor of such agreement or illicit conduct, and if there are certain argument which leads to the probability of harmful against the market competition, the CCI or the other authority or body or court or any judicial or subjudicial body who are examining this or interpreting this rule have look at the balance stage and have to make some balance or harmony before examine this particular conduct. So in this case, rule of reason is basically the test where the positive impact and negative impact have taken into account to take a balance. And if after that, if pernicious effect is considered higher, the activity if prevented by the competitive agency of respective jurisdiction. Like in United States, US Supreme Court in case of Board of Trade of City of Chicago versus United States in 1918, where Justice Brandeis observed as follows. This is regarding the rule of reason, and what he observed that every agreement concerning trade, every regulation of trade restraints, to bind, to restrain is of their very essence. The true test of legality is whether the restraint imposed in such as merely regulate the perhaps thereby promote competition, or whether it is such as may suppress or even destroy competition. To determine that question, the court must ordinarily consider the fact peculiar to the business to which the restraint is applied. So, it in condition before and condition after the restraint was imposed. So, the nature of the restraint and its effect actual or probable. So, the history of the restraint, the evil believed to exist, the reason for adopting the particular remedy, the purpose or end sought to attain, all are relevant fact. And this is not because of good intention will save the otherwise objectionable regulation or reserve, but because knowledge of intent may help the court to interpret fact to predict consequences. So, by this observation, what is given by the US Supreme Court, you can find out that this test is a test where you must adhere on both sides, on the positive impact and negative impact, and you must analyze whether the degree of that probability is probable like the harmful or preventive competition in market or not. If it is, then it can be testified. In this interpretation rule, the burden of proof is on the plaintiff to prove that agreement is violative of competition and mandate, and once the plaintiff discharges the burden, the defendant can escape the liability if it shows that same has pro-competitive aspect, which would otherwise outweigh any harm to the competition. Let's take one more case decided by the Honorable Supreme Court in India. This is an Indian case in Telco, that is Tata Engineering Locomotive Company Limited, was a registrar trade agreement in 1977. This case was deal with the provision of MRTP Act 1969. In this case, the Tata Engineering and Locomotive, that is Telco, entered into an agreement with a foreign company, and the name of the foreign company is Daimler-Benz AG, for the purpose to manufacture the Mercedes-Benz trucks in India. The agreement contained certain restrictive clauses, including a clause that prohibit Telco from exporting the truck into certain countries. The Registrar of Restrictive Trade Agreement under MRTP Act 1969 issued a notice to Telco and stating that the agreement was registrable under the Act. The Telco challenged that notice, arguing that agreement was not registrable as it did not fall within the meaning of restrictive trade practices under this Act. Now, the question is whether it is registrable or not, because the argument is what Telco argues that it is not a registrable because it does not come within the meaning of restrictive trade practice. So, now again one more thing what court have to be taken, that what is restrictive trade practice, what we have already discussed in previous sessions, the meaning of restricted trade practices. But for today, for this session, particularly for this case, if you see, the Supreme Court of India held that the agreement between the Telco and Daimler-Benz AG was a restrictive trade agreement. The case where Supreme Court of India interpreted rule of reason, the Supreme Court held that to determine whether the restraint promoted or suppressed competition, it is necessary to consider three matters. What Supreme Court observed that? Supreme Court observed that if you have to look whether the trade agreement comes within the meaning of restrictive trade practices or whether it restrained or promote or suppressed competition, because the important thing is the act for that purpose if is there any act or conduct comes within the meaning of restrictive trade practices, that means it restricts the competition actually. So if you have to look, you have to arguing on such thing, on such edge, whether it for the purpose of promotion of competition or only for the restraint, or it takes some restriction on competition. So Supreme Court argued that the three tests you have to take to qualify. The first is, what fact are peculiar to the business to which the restraint is applied? The second, what was the condition before and after restraint was imposed? And third, what is the nature of restraint and what is its actual and probable effect? So if you see the rule of reason interpretation, what Supreme Court does not comes within the meaning to in detail to elaborate the meaning of rule of reason or the interpretation of rule of reason, but how Supreme Court actually interpreted this time the question whether it is it comes within the meaning of restrictive trade practices or not. Because if it is about some antitrust practices or anti-competitive agreement or about the some conduct, you have to see that conduct, anti-competitive practices or restraint is within the meaning of unfair trade practice or restrictive trade practice. Supreme Court said that you have to just think about threefold or in a three manner. The first, you have to look whether the restraint is applied, or what would be if the restraint were not applicable, or in the case if the restraint is applied, that means the case before the restraint imposed and after the restraint imposed, whether there may be some changes in consequences or what consequences you can find out if there is a restraint or if there is not some restraint. And the third one, what is the actual nature of some restriction? If the restriction is like that, by the application or restriction or this type of restriction, it has some actual or probable effect. So it is definitely a restrictive trade practice. So with this, these are the important point whether you have to take into the consideration to find out or to interpretation, and definitely these guidelines are the part which become the part of rule of reason. Against one more important case decided in 2012 by the court, that is Cement Cartel case, popularly known as Cement Manufactured Association versus Competition Commission of India in 2012. This is a landmark case in Indian competition law. The case involved allegation of cartelization among cement manufacturers and the Competition Commission of India, which imposed penalties on the company for violating the Competition Act 2002. Rule of reason interpretation, if you see in this code, in this case CCI applied the rule of reason to determine whether the agreement among the cement manufacturer was anti-competitive. The rule of reason is principle of competition law that require an analysis of competitive effect of an agreement or conduct rather than simply looking at its time or form or structure. The CCI held that the agreement among the cement manufacturer, which included price fixing and output restriction, was anti-competitive and violative to Section 3(1) of the Competition Act 2002. The CCI applied the rule of reason to conclude that the agreement had an effect of limiting competition in the market and therefore was prohibited. Again, in Competition Commission of India versus Coordination Committee of Artists and Technicians in West Bengal Film and Television in the year 2017, the Supreme Court emphasized the importance of considering the context and surrounding circumstances while applying rule of reason. The Supreme Court held that CCI must consider the competitive effect of an agreement or conduct rather than simply looking at its form or structure. So these are the cases where Supreme Court and CCI and other at that stage of the argument, CCI, and when it comes before the court, before the Supreme Court, the court observed that rule of reason is a term which is like the rule of interpretation, where you have to look on both impact. That means you have to look the affirmative side or the positive end, or you have to look against the negative impact. You have to make a balance between the both aspect or both argument. You have to examine in between whether the degree of the argument is downing in the side of positiveness, or with it is lying with the it lead to the reducement of competition. What is the probability, what are the possibility, and what should be the effect, what are the probable effect which may comes in future of such conduct. If it is like it will be harmful, or there are probability that it will reduce the competition in market in India, that may lead to the anti-competitive impact or appreciable adverse impact. So, rule of reason is a rule where you have to check and balance at both sides while interpreting or investigating or examining. One more very much important case come in this scenario, that is Rajasthan Cylinder and Container Limited versus Union of India. It decided in 2018. The Honorable Supreme Court clarified that the rule of reason is not a rigid or mechanical test, but rather a flexible and nuanced approach. The court held that CCI must consider the specific fact and circumstances of each case rather than relying on the general presumption of assumption. So, if you took note on this particular case, what Supreme Court observed, that rule of reason is not a rigid or mechanical test. That means it is not a universal application or universal rule or formula which you have to apply in each and every case or each and every situation. You have actually analyzed the situation. You have actually analyzed or examined the scenario under which the competition has to take place or the agreement has been take place, which is in the question, or the conduct or practice which is alleged. And while interpreting the adverse impact on competition within the India, you have to make a flexibility, not like a universal formula. Yes, that is appreciable adverse effect, or that is not as likely to appreciable adverse effect. That means you must consider the specific fact and specific situation in each and every case. Rule of reason is only the rule of interpretation which may be applied or which can be applied for the purpose of interpretation of certain activities, conduct or practices which took place at the certain time or for the particular purpose. So, you have go with the specific fact, you have to analyze a specific situation and even the circumstances for each case rather than only relying on general presumption or assumption. That's why if you see the cases what we have already discussed, in whether it is Rajasthan cylindrical case, Telco Supreme Court's case, or any other judgment like the cement manufacturer India case, you will find that rule of reason is basically not the rule of presumption, rather it is a rule of construction. Rule of reason is not such rule which has some universal effect or which you can use as a universal formula. You have to construct the matter, you have to testify within the limitation of argument from the both side. You have to take balance, you have to make a harmonium. If you testify, if you are examining some conduct or practices, whether these practices or conduct is anti-competitive or the conduct is probably lead to the adverse impact on market, you have to construct the situation. That's why the rule of reason is known as rule of construction, wherein the investigating or prosecuting agency establish or establishes existence of anti-competitive agreement by considering all the fact features of the case. So with this, if you are in a presumption, like the rule of reason is like a presumption rule which can be applied, or you can impose it on certain type of agreement. No, this is not. We will discuss again if we in next session the what is the rule of per se and what is the difference between per se rule and rule of reason. No doubt earlier it was a propaganda that rule of reason is applicable in certain type of agreement, like in only vertical agreement, and rule per se is like a assumption rule which can only be used as a tool of interpretation in horizontal agreement. But you will find and you will see while the discussing in next session that it is not a universal formula and it is not a rule which can be applicable in only certain situation. Now the condition is there are some rules, and now what we are taking in this session, that is only the rule of reason. And for today's session you have to go with some strict line that rule of reason is a reason which is a construction rule. Rule of reason is a reason where you have to examine both the factor before restriction and after the restriction. That means it is a rule to make balance and to examine after arguing from the both sides. So with this, we will discuss the next interpretation rule, which is known as rule per se, in next session. So for today, thank you very much.